Welcome back to Central Colorado Ballistics. My name is Wally. Reconstruction ends in 1877. Federal troops withdraw. Military occupation ends. Virginia is redeemed. But redeemed by whom? And for what? The Civil War is over. The 13th Amendment has abolished slavery. The 14th has defined citizenship. The 15th has prohibited racial discrimination in voting. On paper, rights have expanded. In practice, authority adapts. In 1877, the compromise that resolved the presidential election effectively ending Reconstruction enforcement in the South. Virginia had already been readmitted to the Union in 1870, but federal presence still mattered. After 1877, local control consolidated. White conservative Redeemer governments regained full authority. And with control came restructuring. Not necessarily dramatic new firearm bans, not sweeping confiscations, but administrative control, selective enforcement, discretion. Freedmen had sought arms after the Civil War for one reason: self-defense, against private violence, against intimidation, against groups that operated outside formal law. But once federal enforcement receded, local officials regained leverage over who could exercise rights safely. The question shifted from, do you have a right, to, can you exercise it without consequence? And this shift was not happening in isolation. In 1873, the United States Supreme Court decided the Slaughterhouse cases. The court narrowed the meaning of the 14th Amendment's privilege or immunities clause. That decision limited how the Bill of Rights could be applied against the states. Federal protection contracted. State authority expanded. Then, in 1883, the Civil Rights cases, the court struck down the Civil Rights Act of 1875. Federal enforcement against private discrimination collapsed. The message was clear. Washington would not aggressively supervise Southern governance. States, including Virginia, regained broad regulatory spaces, not by rewriting the Constitution, but by narrowing its enforcement. In the late 19th century, Virginia did not pass sweeping new statewide disarmament statutes. That is important. Instead, regulation operated through concealed weapon restrictions, local enforcement discretion, surety laws, licensing authority. In many cases, carrying a concealed weapon required approval from local officials, often a mayor or court. Permits were discretionary. Approval was not automatic. There was no standardized statewide review structure. In a political climate dominated by Redeemer leadership, discretion was not neutral. A law written in universal language can still be administered selectively. And in the late 19th century South, selective enforcement was a feature, not a flaw. Virginia had long prohibited certain concealed weapons. The late 1800s saw expansion and enforcement refinement. The emphasis was not on muskets. It was not on militia rifles. It was increasingly on handguns. Urbanizing areas, Richmond, Norfolk, were growing. Industrialization changed social patterns. Public carry became associated with disorder rather than defense. But enforcement patterns mattered more than statute language. And enforcement discretion in post-Reconstruction political climate was not neutral. The law on paper can be universal. Application rarely is. Virginia law also restricted the carrying of weapons in certain public settings. places of worship, public gatherings, and in some instances carrying weapons on Sundays away from one's own premises without what statute called good and sufficient cause. These restrictions reflected on emerging moral order framework. Firearms were increasingly associated with disorder when carried outside narrowly defined acceptable contexts. Public order, not militia readiness, was becoming the governing lens. While many of these statutes were written in racially neutral language, their enforcement occurred within a racially stratified society. Black Virginians, particularly in urban areas, and in disputes framed as disorderly conduct, were disproportionately vulnerable to arrest, prosecution, and permit denial. The law did not need to name race. The enforcement structure already understood it. Selective enforcement can function as control without ever announcing itself as such. In colonial Virginia, arms restrictions focused on allegiance, native tribes, enslaved persons, those refusing loyalty oaths. After the Civil War, allegiance was no longer the dividing line. Citizenship had been constitutionally defined. The new dividing line became legitimacy. Who counted as a responsible citizen? Who counted as a threat to public order? Vagrancy laws expanded. Convict labor systems grew. Felony status increasingly carried civil disabilities. Virginia did not need to rewrite the Bill of Rights. It needed to redefine the structure beneath it. Political participation shrank, and with it, the practical ability to contest enforcement. Between 1877 and 1902, Virginia's political leadership worked toward one objective: permanent control. The 1890s saw open discussion of constitutional revision. The target was voting. But voting is power, and power shapes enforcement. In 1901 to 1902, Virginia convened a constitutional convention. Its purpose was not subtle: to eliminate what leaders called the Negro vote without violating the 15th Amendment in explicit language. The result was the Virginia Constitution of 1902. Notably, the 1902 Constitution did not contain an explicit individual right to keep and bear arms. Virginia's governing document during this era was silent on a modern personal right to firearms. The language affirming that the right of the people to keep and bear arms shall not be infringed would not be added to the Virginia Constitution until 1971. In this period, firearm rights existed primarily through statutory structure and federal interpretation, not through an explicit state constitutional guarantee. It introduced poll taxes, literacy tests, complex registration systems. These did not mention firearms, but they restructured who had political voice. And political voice determines how rights are defended. By 1904, black voter registration in Virginia had plummeted dramatically. Representation narrowed. Authority centralized. When participation shrinks, oversight weakens. By the turn of the 20th century, Virginia was entering a new era: industrialization, urban policing, professional law enforcement. The militia model of 1776 was no longer the organizing principle. The National Guard replaced informal musters. Police departments replaced ad hoc enforcement. The conceptual shift was profound. From citizen defense structure to state-managed public order. Firearms were no longer primarily viewed as mandatory civic equipment. They were increasingly framed as regulated personal property, especially concealable arms, handguns. Portable, concealable, and associated with interpersonal violence became the focal point of regulatory attention. The state did not attempt to eliminate firearms. It refined which types, which methods of carry, and which circumstances would trigger scrutiny. The regulatory question was no longer whether arms were essential to liberty. It was whether their presence aligned with the state's definition of order. Virginia's 1776 Declaration of Rights helped influence the language that would later appear in the Second Amendment. But by 1902, its internal governance emphasized control of participation, not expansion of autonomy. The template had changed. From 1877 to 1902, Virginia did not abandon the language of rights. It adjusted the structure beneath them. Federal enforcement receded. Local authority strengthened. Participation narrowed. The question was no longer, should citizens be armed? It became, which citizens hold influence? Virginia authored foundational language about militias and liberty. But history shows something consistent. When power feels threatened, control expands. When participation narrows, oversight weakens. The Constitution can remain. The structure beneath it can change. In the next episode, we enter the 20th century, where modern gun regulation begins to take recognizable shape, and Virginia must decide whether it leads, follows, or adapts. Freedom secured, rights defended.